Picture this: a justice system teetering on the edge of total breakdown, with suspects charged today potentially not facing trial until 2030. That's the alarming reality gripping England and Wales right now, and it's about to change in ways that could reshape how we think about fairness in the courtroom. Stay tuned, because this overhaul isn't just about speeding things up, it's sparking debates that cut to the heart of our democratic traditions. In a bold move announced just hours ago, Justice Secretary David Lammy revealed that jury trials will be eliminated for offences carrying potential sentences of less than 3 years. This is part of a broader initiative to combat record-setting delays in the courts, introducing swift courts designed for quicker handling of less serious cases. Think of these as streamlined judicial pathways, where decisions are made faster to clear the massive backlog without the full jury process. But here's where it gets controversial. While major crimes like murder, robbery, and rape will continue to demand the scrutiny of a jury, everyday offences, those that make up the bulk of prosecutions, will shift to a different system entirely. Lammy described these changes as both bold and essential, aiming to prevent what experts warn could be a complete collapse of the legal framework. The plan draws heavily from recommendations by retired Court of Appeal Judge Sir Brian Levison, who was tasked by the Lord Chancellor last December to propose fixes for the overwhelmed courts. You can dive deeper into his full report at https://www.bbc.co.uk/news/articles/C5Y85LWPZV30. His suggestions included ditching juries for certain cases and promoting alternatives like out-of-court resolutions, such as cautions, essentially warnings or agreements that avoid full trials. Back in July, Levison emphasized that fundamental reforms were crucial to avert disaster. An earlier draft of the plan, leaked to the BBC, check it out at https://www.bbc.co.uk/news/articles/C7VDViso, and The Times, floated ending jury trials for crimes with sentences up to 5 years. But in his announcement to Parliament on Tuesday, Lammy dialed it back, settling on the 3-year threshold. He explained that this new approach could resolve cases about 20% faster than traditional jury setups. Why the urgency? Current forecasts predict Crown Court caseloads swelling to 100,000 by 2028, up from the existing backlog of nearly 78,000 cases. To put that in perspective, for someone accused of a crime today, a trial might not happen until the distant future of 2030. That's years of limbo, uncertainty, and potential injustice. Alarmingly, 6 out of every 10 victims of rape are reportedly dropping out of prosecutions due to these frustrating delays, highlighting how the system is failing the very people it aims to protect. Under the reforms, defendants won't be able to simply opt for a jury trial in cases that could be handled by magistrates or a new judge-only Crown Court setup. This tweak is intended to stop people from gaming the system, essentially, exploiting options to delay proceedings. Additionally, accusations involving fraud and intricate financial crimes will no longer involve juries, following advice from a retired senior judge earlier this year. For context, beginners might wonder, magistrates are volunteer community members who preside over most criminal cases, handling everything from minor theft to traffic violations, while the Crown Court deals with more serious matters. England and Wales see about 1.3 million prosecutions annually, with just 10% escalating to the Crown Court. Of those, around 3 in 10 actually go to trial. The proposed changes suggest that more than 2 in 10 will still feature juries, preserving that element for a significant portion of cases. But here's the part most people miss. Critics, including nearly all barristers, those specialized lawyers who argue in court, argue this won't dent the backlogs one bit. They point to deep cuts in funding for the Ministry of Justice as the true culprit behind the congestion. There's also evidence suggesting that ethnic minorities often feel they receive a fairer treatment from juries compared to magistrates alone, raising questions about potential biases in non-jury systems. Lammy himself has flip-flopped on this. Previously, he called cutting juries a mistake, but ahead of the announcement, he told the BBC that evolving realities demanded action to tackle the pile-up. Opposition from the Conservatives has been fierce. Shadow Justice Secretary Robert Jenrick blasted Lammy for scrapping an institution he once praised, questioning the lack of a mandate from the party's manifesto. Why does this Justice Secretary believe he can dismantle centuries of jury trials without so much as a nod in his agenda? Jenrick challenged in Parliament. Lammy countered that the prior government slashed court days, and besides, magistrates already manage the overwhelming majority of trials in the UK. To implement these shifts, new legislation will be required. Solicitor Advocate Abigail Ashford from Stokoe Partnership, who defends clients in the Crown Court, warned that judge-only trials could widen inequalities and erode public faith. In nuanced or emotionally charged cases, excluding the community from weighing credibility and equity chips away at trust in a manner no single judge can fully restore, she said, emphasizing how marginalized groups might feel even more disconnected. The Criminal Bar Association, representing expert criminal lawyers, lambasted the plan as swinging a wrecking ball at a time-tested system. Juries excel, they perform their duties flawlessly, free from prejudice, their statement declared. They aren't behind the backlog. Chair Riel Karma-Jones KC also voiced worries over the vagueness in Lammy's remarks, calling for more specifics. On a brighter note, Tom Franklin, head of the Magistrates Association, welcomed the expanded role for magistrates as a strong endorsement of their abilities. Yet, he stressed the need for more support, like better-trained legal aids, fair pay, and upkeep for dilapidated court buildings. He advocated for swift courts to include 2 magistrates alongside a judge for both verdicts and sentencing, as Leveson initially suggested, ensuring everyday people stay involved in the process. And this is the part that really gets under people's skin. Is sacrificing jury trials for efficiency a necessary evil, or does it undermine the very essence of democratic justice? Some might see it as a pragmatic fix for an overburdened system, while others fear it's the slippery slope to eroding rights. Do you believe these changes will truly speed things up, or could they deepen divides in trust and fairness? Is this reform a forward-thinking solution or the start of dismantling a cherished tradition? We'd love to hear your take, agree, disagree, or somewhere in between. Drop your thoughts in the comments below and let's discuss.